Sure, please, please. Oh, yes.
So just to speak to some of these things, inshallah. So 1/3 discretionary bequest to those who are not receiving a Quranic share. An example would be like an adopted child, right? Like we spoke about, you can use to give to that, but you can't give it to someone who already has a share, right? Males can waive their extra share, right? So this is something that, okay, if the will is Allah subhanahu wa ta'ala says لِلذَّكَرِ مِثْلُ حَظِّ الْأُنثَيَيْنِ, right? That a male child will get the share of 2 female children. This is the system of Allah subhanahu wa ta'ala. Now, if a father was to say to his son that, you know what, after I pass away, this is your share, you cannot say that you have to do this, because it's not yours to get, it's his share, it's his wealth. And so you can't say, well, you know what, you have to give this much to your sister. It's not allowed, right? You can say, you know what, it'd be nice if you give, and maybe think about it. And then if he wants to give out his own volition, then that's fine. You can give the advice, and but the ownership is of the inheritor, right? So Daniel, Ibrahim, and myself were having discussion on, you know, is this something that someone can do before before the will is written, that, you know what, oh yeah, when my father passes away, I already give half of my share, I already give this portion of my share to my sister, and so the will is written like that. This is not permissible. It's not permissible, right? The will has to be, so I can't give you something that I don't own. If I don't own it, I can't give it to you. I can't say, oh, you know what, this is coming to me from, you know, we don't know who's going to pass away first, right? But this is coming to me from so-and-so, or it's going to come to me. When it comes to me, then you can already have it. No, there's something that's called tamlik, right? Transfer of ownership. Transfer of ownership is necessary before someone is able to give what is theirs to someone else, okay? Now, with regards to a joint title with spouse and so on and so forth, this is, in today's time, you know, something that it's completely personal, right? And something that you would to decide yourself. But if you wanted to, a joint bank account, if you have a joint bank account with the intention that this is half is mine, half is my wife's, right? Then it's a very simple system. Half of it is your wife's. It's her ownership during your lifetime as well, right? Also with regards to the home, right? If it's very clear that, you know what, this home is a joint home, we're owning it jointly, it's clear, everybody knows it, it saves a lot of problems, right? Now with regards to the insurance, just something that I want to clarify. Again, there may be different opinions on this. Life insurance is, I don't think there is any different opinion, right? It's haram, right? It's haram. You can insure your life because death is guaranteed, right? However, if it's given from like a third party, your company is giving to you, and you don't have a choice, but some of your money goes into it, right? When the life insurance is made, some portion of your money is going into it. The majority of scholars are of the opinion that in that case, you taking the whole insurance amount is not permissible, even though it's not yours, even though you haven't made the decision, but it is an illegitimate income source, right? Because it's life insurance, whoever does it, whether it's done or not, it is not correct. So for us to use that wealth would be incorrect. So the scholars say that what you can do is it's difficult to do, but if you were able to kind of calculate how much of your wealth was given into the policy. So a person is paid, for example, over the period of whatever amount of years, $30,000 has gone into a policy. That $30,000 is permissible for you to take advantage of because it's yours. The rest of it would not be considered to be permissible, right? So this is, again, there are different opinions, but this is the opinion that we follow. This is a safer kind of opinion, inshallah.
Thank you, Shaykh Abdullah. And just just to follow up what Sheikh Abdullah said, Imam Nadawi said the same thing, and he actually recommended, I'm talking about the joint property with the house, he actually proactively recommended to protect widows in this society to make your house joint, but have that intent, as Sheikh Abdullah said, half and half. So all I wanted to mention from that case is a real case of the son kicking the widow, his mother, out of the house. We're trying to make sure when you do the joint property, you tell your wife this is half yours, and then tell all the children, I'm giving it now while I'm alive and healthy, half to your mother, don't kick her out, basically. And that's the whole point of Islamic law with the 2/3, is to avoid these fights. Everybody knows what they're getting. Yes, now, the sadaqah, 1/3. In that hadith that Sheikh Abdullah mentioned, I forgot that it was a daughter was the heir, as Sheikh Abdullah said. So look at that, Rasulullah was trying to make sure there was as much money left over for the daughter, not a son. So that shows how much he cared for the benefit, for the emancipation of women, subhanAllah. So now, the sadaqah can go up to 1/3. Now the advantage in Canada, I just want to let you know, if like you give to a masjid or another registered charity, you can basically write off all your income tax for your final year of life by donating it through your will to a registered charity like a masjid. So basically, we're still limited as Muslims to the 1/3, but in Ontario you can basically have all the money that you're going to pay in income tax, give that to sadaqah, and basically you instead of it going to the government, it goes to the registered charity of your choice, basically. But remember, in that hadith that Sheikh Abdullah mentioned, and another one, and Sheikh Abdullah can talk about those, the sadaqah is better during your lives. So a lot of people just try, oh, I'll do all my sadaqah on your death. Please do your sadaqah while you're alive. That's when it hurts more, basically. Like all these billionaires are promising to give away all their money when they die, but we need them to do it now, basically. Before I go into this about how the process actually works, on the wife getting or the woman getting only half the share of the man, that's in the same category in class. So basically, just wanted to clarify that. Of course, Sheikh Abdullah can talk more about it. So a daughter gets half of a son, a wife gets half of a husband, and so forth. But that doesn't mean that a woman is always getting less than the man in the will. So the great example I always try to remember is, so let's say a woman passes away, leaving a husband, a daughter, and a father. So guess who gets each share? So basically how you do it, the woman died. The first share goes to her husband. Because of her child, he gets 1/4. Then the daughter, there's only one daughter, she gets a half. There's no sons in this example. She gets a half. And then the residual heir is in this case the father, who gets what's left over. So if you take 1 minus a half minus a quarter, what's left over is a quarter. So subhanAllah, 1400 years ago, a woman dies. She has a father and a husband who are both dominating in patriarchal cultures, and say an infant daughter. Neither the husband or the father could take 1 dinar, 1 penny, $1 from the infant daughter, who gets almost the majority, gets half the share. SubhanAllah. And that is her right. Even if she's a child, a trustee has to manage it for her benefit, and neither the husband or the father can take it. That to me is like revolutionary, and it's just extraordinary. SubhanAllah. Now, how do we practically move forward? So basically, how the process works in Ontario, or how we do it, is we ask you some short questions by email, just which are the demographic data, like your date of birth, your citizenship, the names of your spouse and children, and so forth. Then what assets you own, and so forth. So who the people are and what you own. And then we have a dialogue on that, where we speak about that, and then we talk about appointing the executors and guardians for the Ontario will. We consider other tax and trust issues, depending how complicated your situation is. We draft the will, you review it, and then we meet. And before COVID, we had to meet in person, but now, since COVID, the Ontario government changed the law, so we can do the whole process remotely. Now, how much does it cost? Usually people want to know. Usually it's about $500 for the first will and a couple hundred for the spouse as well. How long it takes? So each call, normally I speak like an hour or 2 hours with the client. But I do flat rates so that it doesn't matter how long it takes. But it takes 2 hours to speak with the client. Then it maybe takes 4 to 8 hours to draft the will, depending how complicated it is. And then we meet and review it, which is another hour. And then to review it in the sense of making any adjustments and corrections. And then we meet to sign it, which is maybe about half an hour, and then the process. So the whole process takes a lot of time to do it properly. But I try to keep it accessible so it's like a flat rate, so it doesn't matter how long it takes. Now, some people ask about precedents, that there's wills out there. So there's no one will precedent for everybody. You could say there's maybe 20 types of cases that are like 95% of the cases. But even then, there's flexibility. So people say, why can't I just sign a precedent, like sign an existing will? You can do that, but I wouldn't recommend it if you have minor children, like children under the age of 18, and if you have any money over $50,000, or you own a house, or you have a disabled child, or you have a business. Now, as a lawyer, I should tell you that everybody should have a will. Islamically, Sheikh Abdullah said that, and that as Muslims we should. But practically speaking, you probably don't need a will if you don't have any children and you don't have any money, basically. It's still better to do it, but I don't want to, not in good faith, say you have to. But basically, if you have children under the age of 18, you need to name the guardians. If you have property over 50,000, the government is a bit more lenient on small estates, less than 10,000, less than 50,000. But if you own real estate, or you have a bank account with $50,000, you should, or more, like real estate in your own house, you should, or condo, whatever, you should get a will, and especially if you have a disabled child and so forth. Now, I'm just saying that as an Ontario lawyer. As Muslims, we should do this generally, as Sheikh Abdullah said. And I think that's it for now. Maybe if you have any questions. And thank you again to Haltul Masjid. Thank you, Sheikh Abdullah. And inshallah, we can discuss more of the equity issues going forward and others. Thank you. Yes, question.